Good morning, everybody, and welcome to the DC Court of Appeals. We have one case scheduled for argument this morning. It's Office of the People's Counsel for the District of Columbia versus DC Water and Sewer Authority. Case number is 22 AA 449, 22 AA 450, and 22 AA 469. Counsel, whenever you're ready.
Very well. Good morning. May it please the court, Scott Strauss for the Office of People's Counsel of the District of Columbia. I'd ask to reserve 4 minutes for rebuttal. In 2018, the City Council heard citizen complaints that DC Water's bill dispute process was stacked against them. The council responded by seeking to level the playing field by authorizing OPC to represent and advocate for water consumers. Today's consolidated cases demonstrate the wisdom of the council's action. DC Water concedes that Mr. Mellum made a prima facie case showing that the 34,000-gallon water bill he received for his alleged use during 1 week in February 2021 was inaccurate. Under this court's decision in Gatewood, that concession shifted the evidentiary burden to DC Water.
Before we get into sort of the merits of the underlying claims, can we just talk about the predicate question of whether or not OPC gets to be a party to this appeal?
Certainly, Your Honor.
Okay.
DC Water concedes that under the 2018 Act, OPC can appeal in its own name.
Are you highlighting footnote 11 of their brief?
Yes.
That's not quite what they say. I mean, I'll let them speak for themselves, but what footnote 11 says is Court of Appeals, you can rule narrowly and say they definitely can't bring cases in their own name when it has no cross-cutting interest for DC ratepayers writ large. But you could say that without saying, and even if there is a cross-cutting issue, maybe they can. So they're kind of bracketing off that question, but at no point do they, I don't think, again, Mr. Hirsch can speak for himself. I don't think anywhere in footnote 11, and maybe you can point me to something else where you think they've said it. They say, and they definitely could bring those cases in their own name, or even suggest that you could. In fact, I think their argument is pretty clearly the extension of it is that you can't no matter what.
Their footnote essentially posits that there's some kind of dividing line. That's how I read it, that there's a dividing line and certain kinds of cases OPC would be permitted to bring in its own name and others it would not.
But they've clearly moved to dismiss the appeal here and they still maintain that the appeal should be dismissed here. So clearly, whatever else they're saying about other cases, they're saying that in this type of case, you cannot appear as the party, right, before us.
Well,
so that's
certainly they're attempting to dismiss the appeal. You're correct, Your Honor. But there's several reasons why the appeal is properly before you. First of all, the dividing line that they talk about isn't in the statute. The statute speaks to the authority on the part of People's Counsel to represent and advocate for water consumers. So that would mean that certainly where the cases at least raise broader questions, process questions that impact OPC's ability to do its job under the law, they ought to be able to bring the cases in their own name.
So why did OPC just represent below and not have it in its own name there and then switch at this level?
I'm sorry, I had trouble hearing you, sir.
At the administrative hearing level,
Right.
the cases were in the names of the individual ratepayers.
Right.
Why is it switched now? And OPC was representing the individual ratepayers at both of the administrative hearings. I believe it was Ms. Beltran. Why change now at this level?
Well, OPC essentially had gotten authority from the customers to bring these appeals, as we made clear, certainly in the affidavit, but had said previously that represented to that effect. Our understanding when we brought the appeal was we were essentially appearing on behalf of OPC with respect to the process questions and representing the customers with respect to their individual disputes. Certainly the petitions in these cases in their caption include the case number and the customer account number. The customer decisions are attached to the petitions. The customers are referenced in the petition.
But I mean, it seems like, these are at bottom individual ratepayer cases, right? I mean, that's what's at issue. And so if your position is you had the consent and permission of the individual ratepayers to appeal, then, and you had represented them but not appeared in your own name below, then it seems like you could have achieved those same goals simply by appealing, representing them on appeal. And if you prevailed in this court, then you would achieve the same goals that you're seeking to achieve by appearing in your own name.
There's no question we could have presented this as OPC on behalf of the customers and OPC on behalf of itself. We do think under this court's Rule 15 and precedent under that while it may have been inartfully presented, OPC in filing this appeal was appealing on behalf of itself and the customers.
Okay, so I mean, I just want to be clear factually there. Is it factually or otherwise, is it your position that this was an intentional decision by OPC to appear in its own name, or that this was a result of inadvertence?
I think it was more the result of an inadvertence. We went and sought authorization from the customers before we filed the appeal. We obviously intended to be there on their behalf as well.
I mean, that is a strange position, counsel, given that your opposition to the motion to dismiss highlighted that if you don't have the right to bring these cases in your own name, well, then the decisions to bring these appeals will be dependent on consumer consent, the ratepayer consent. This was kind of the big argument. It was like, we shouldn't be held hostage to whether or not the ratepayers want to bring an appeal. We should be able to make that decision for ourselves. Now, I understand you have now sort of come limping in a little late to say, in fact, we had ratepayer consent, which would have been a perfectly, I think, a much more palatable argument if you had made it in response to the motion to dismiss and say, we had consent, let's just amend this pleading now. But your position was quite different. It was like, we brought it in our own name. We intended to bring it in our own name. We should be allowed to bring it in our own name. And if you don't let us bring it in our own name, we're going to be held hostage to ratepayers' consent to appeals, and we don't want that. So, I mean, the position seemed just wildly different to me. So tell me why the about face and why we should really take it as being an earnest one.
I believe that we had the ability to bring the case in our own name. We also had gotten authorization from the customers and believed in this first case under the statute that we were appealing both on behalf of OPC with respect to process injuries and with respect to the customers with respect to the underlying dispute. There was no intention to cut the customers out of this. It was actually quite the contrary. The reason the affidavit came in late is that we believed that it was clear at that point where we were and why we were doing that. When it was referred to the merits panel, we thought, well, look, let's just make this absolutely clear. There shouldn't be any dispute about this. And we put in the affidavit. Should it have come in earlier? Sure, perhaps. Was there any prejudice from the fact that it came in when it did? None has been alleged, and I don't know why there would be any.
So I know it's not the case here. You did show that you had the consent of the ratepayers. And I'm also not saying you would ever necessarily do this. Maybe you wouldn't, but is it your position that if a ratepayer said, I'm fine with the decision of the administrative hearing and I'm ready to walk away, that you could still bring an appeal in your own name?
I think if the ratepayer did not consent, clearly, Your Honor, that would be a much more difficult question. And if the ratepayer specifically said not to appeal after we had represented them, that would be an even more challenging.
But I mean, it doesn't seem to be a more difficult question. It seems to be the natural result of the argument that you're making, because if you can appear in your own name, perhaps you would prudently get the ratepayers' consent, but it seems to be the position that you don't have to.
Well, let's take the situation where, for whatever reason, we were unable to reach the ratepayer. And we wanted to bring the case anyway because we thought it raised broader questions. I think we would have the authority to do that in that case. Our ability to advocate under the statute says we can represent and advocate. Those are different words, and we thought that the word advocate should be read to have a specific meaning.
Is there a
Advocacy before this-
limitation on what you'd be able to go for?
with
Is
this-
there a limitation on what you'd be able to go for in that scenario? You remarked earlier that that OPC is representing itself in its own name on the procedural and broader questions that may or may not have some effect on the merits of the matter, but that you are representing the individuals on the specific merits of their cases.
Yeah, I think that would have an impact, Your Honor. If there aren't broader questions, then it would be more difficult for OPC to support standing on its own to raise those questions. These cases do raise those broader issues. The status of an expert. Do you need one? Is there a certification requirement? That's a broader
I
question.
mean, it seems like anytime you have an individual ratepayer case, you're going to at some level have broader questions in terms of the way the decision came out and how the hearing officer handled it. But those, I mean, that would seem to suggest that you would always have independent standing to bring a case on your own.
Oh, I think in many cases, we would have independent standing to bring it up
Can you give me an example of a time when you wouldn't?
when we would not have an ability to bring a case on our own. When it was
I mean, the ratepayer lost before the hearing officer and you,
I think if it were simply a question that the evidence was insufficient, that might not be a case that we could bring on our own. Here, there was a determination, for example, in the Mellon case, a categorical determination that we needed to certify an expert. That raised a broader question. The Roberts case, when a customer calls, and these are citizens, when they call up DC Water and say, something's wrong with my water bill, can you help me? Is that sufficient to constitute a challenge? What will a customer have to do? Are there magic words? So there are ways in which, yeah, there could, that, I would assume in many cases, if not most cases, you're correct that the broader questions and the individual ratepayer questions come together. But there can be instances where they're separate, and OPC needs the ability to raise those. And I think that's what the statute intended.
And can I ask you why? I mean, you're reading a lot into the word advocate, but why should we assume, I mean, why do we think DC Council didn't just use the same language it used in 34804?
Because I think the purpose of this statute, which was enacted in response to complaints about an unfair billing practice that was stacked against customers, that the idea was to enhance consumer protection. So why would they have adopted a term that limited OPC's ability to do that? The whole point was to expand it. Reading it that way, reading it like we chose the wrong word, therefore we really intended to truncate what they could do, I think would be contrary
It's
to
not
what they were trying to
truncating. It's not,
purpose.
in no way does it truncate what you do. It certainly expanded your ability to represent and advocate for ratepayers in DC water cases. But the question is, are you the party in interest or is the ratepayer? And if you look at 804, it says very clearly in 804A that as to other utilities, the office shall be a party as of right in any proceeding. That language is not present in 2202.05, and its absence, I think, is quite striking, as is the absence of any indication that you can appeal, which is made explicit in 2202.05. And the only difference is the ratepayer the one that controls the litigation? Does it need to be in their name? And they can say, stop OPC, we don't want this to go any further. Or is OPC the one who controls the litigation? Either way, it's an expansion of OPC's ability to represent those ratepayers. It's just a question of if it's at their election or if it's at your election.
The words are represent and advocate. They're separate words. We believe they were intended to have separate meanings.
It talks about advocate at public hearings as well, like advocate at public hearings for, I mean, we can go through 20, there's a lot of ways in which you can advocate for policies and advocate for consumers without representing them in litigation. They have independent meaning either way.
You're correct, except that particular provision refers specifically to advocacy before courts, agencies and courts. The way to advocate, then the phrase represent means representing a client. Advocate before a court, if you're not representing them, if it's to have a separate meaning, would mean you bring your own case. And we think that, and it refers to advocate on behalf of water users. If there are instances in which the cases raise a broader question, then OPC should be able to bring them on their own.
Why? Why not, act as amici?
Say it
You
again?
can act as amici. You can file friend of court briefs. You can do exactly what you did in the proceeding below. You can show up on behalf. In that case, you represented them, I believe formally represented them, but you need not. You could have somewhat divergent interests and advocate for middle ground positions that affect all DC ratepayers that aren't necessarily representing a particular client.
It's true. It is correct, Your Honor. And as we said, we believed in filing the appeal. While we filed it in our own name, we believed we were also filing it on behalf of the interest of the ratepayers. To demonstrate that that was absolutely the case, we submitted an affidavit to show the evidence of our standing. And we believe under this court's precedent that the petitions we filed were sufficiently broadly worded and informative that it was clear that the customers were appealing as well. There has been no claim by the other side that they were prejudiced, that they didn't know what this case was about, that was unfair surprise, that these issues were in the case.
Do you think I've stated the stakes of this case accurately when I say the only question, it really doesn't affect what OPC can do and can't do in any given case, except the question is whose election is it at? Is it at the ratepayers election or OPC's election? Do you think I've understated your interest in this issue?
No, I think the question is whether we can appeal in our own name in particular situations, or whether we always have to have customer consent to go forward as in these proceedings. I think that that's correct. I do think in this case, both sets of interests are present. There are interests with respect to the process, and we want to be able to do a good job. So we bring those issues here, but we brought them with the customers because plainly we were appealing particular decisions. That's why we attached them. That's why we put the account numbers in the caption. That's why we put the case numbers in the captions. We wanted to make clear that this was all in front of the court. And we do think that that's the purpose of the statute, to enable OPC to, as broadly as possible, protect customers here. And these customers needed protection. If I may spend a few moments on the merits. With respect to Mr. Mellon.
Well, before you go there, I have
Sure.
one more question. I want to probe your view of this authority. So much like in an another regulatory scheme, the director of the Office of Human Rights can initiate investigations in cases under a director's inquiry. Would you argue that that advocate would give OPC the authority to say, file an equitable action at Superior Court citing to a number of these cases, like the two you're appealing today, to challenge procedures and compliance with regulations?
I think the word advocate broadly and before courts gives LPC a full panoply of rights to do what would be necessary to protect the interest of water users. That was the idea. And certainly Mr. Mellon needed protection in this case, if I can continue. He made a prima facie showing that he received that his claim that a 34,000 gallon water bill he received for a week in February of 2021 was inaccurate. And under Gatewood, that showing shifted the burden to DC Water to demonstrate a malfunction was not the cause. The record indicates the usage was wildly out of line with the household usage, which returned to normal a few days after the spike. He immediately called DC Water. He hired a plumber to come out the following week who took a look around, couldn't find any evidence of a leak, couldn't find any evidence of physical damage, which would, obviously you would see some if enough water to fill a swimming pool had been released without your knowledge. The homeowners testified they didn't use the water. An engineering expert from OPC, who was the only expert in the proceeding, provided a reasonable explanation for what happened. He pointed out that there are two parts to the water meter. There's the meter and then there's the unit that transmits the results to the agency. And he explained that even if the meter is functioning properly, there can be some forms of interference that prevent the transmitting unit from transmitting the appropriate load file. You get a calibration error. And he said, for example, software upgrades could cause that kind of thing. And he didn't know whether there'd been software upgrades. Now, in response, DC Water testified to an investigation that was delayed and incomplete. DC Water says that it needs to test water meters immediately because evidence erodes over time. That's in the record at page 595. The agency tested the meter here 10 months after the incident, which is not immediately, and 3 months after they had denied the claim by Mr. Mellon. But it ran no tests on the unit that transmits the meter. That's admitted in the record at pages 960 to 961. And its witness testified she didn't know if there had been software upgrades during Mr. Mellon's high water week. The hearing officer then compounded this by discounting the expert testimony. She faulted OPC for failing to ask that he be certified, but there is no certification requirement. Her decision was also arbitrary because, as we point out in our brief, in a case several months earlier, she had accepted the testimony without requiring a certification. And of course, it was highly prejudicial.
Do you think DC Water offered an alternative explanation of what would have explained this spike? I don't recall one.
I don't recall one either.
Okay, maybe they
No.
can tell.
I think their explanation was 10 months after the fact, we tested the water meter. It was correct. We didn't find an error on the transmission log. You used the water.
Was there any evidence about, other than sort of raw data, about, would you need to have had 3 showers running constantly and 4 hoses going at the same time to accumulate 30,000 gallons? Or, I can't conceive, and I don't know what the evidence was like of how difficult of a task it would be to run that much water in a few days.
The short answer is very. There was a statement on the record by one of the customers, one of the Mellons, to the effect that, I'm trying to remember where it is in the record, I'll find it. It required a certain number of gallons per minute. That was a very, very high amount of water to fill I think it was a 20 by 40 foot swimming pool.
And so DC Water did a little more than you said. So they tested the meter. It was 10 months after, but they also put forward testimony that meters don't self-correct.
That's correct.
So if the meter was working 10 months later and they don't self-correct, then the implication that they were at least trying to proffer was that it was working 10 months earlier.
You're correct, Your Honor, but they also said that evidence erodes over time. I don't know what other kinds of evidence they were talking about, but they made the point, for example, with respect to Mr. Roberts, we can get to in a moment, that his delay prejudiced them because evidence erodes and they needed an opportunity. Their purpose is to test immediately. Mr. Mellon told them immediately. He had a plumber come in and say, look, this didn't happen. They waited 10 months to test it. During that time, they sent him robocalls saying they were going to disconnect him for non-payment of bills, even though he had complained properly, and then announced, look, the meter tested accurately, only as the OPC had come in and said, where were the meter results? This was not a model investigation.
Counsel, let me ask you, I want to clarify a point there too in response to Judge Shanker's question.
Sure.
I understand that the meter itself doesn't get changed or self-update, but these are smart meters. Software can be changed and firmware can be updated. And in fact, for security purposes, may periodically occur. Is there testimony relating to that, or was that
Yes,
point about not changing related just to the hardware?
Well, no, there was testimony from OPC's engineering expert to that effect, Your Honor. I believe it's in the record around page 938, 939. He explains that he is an expert on smart meters and has seen instances where there are software and firmware upgrades and they cause problems. He referred to them technical terms as a glitch, but he said that glitches correct themselves while meters don't. And in this instance, DC Water acknowledged they did not test the meter transmitting unit.
Can I ask a very technical question?
I can try. Go
Okay,
ahead.
well, they probably won't come out right in my asking either, but was the testimony that the glitch was in the digital meter reading accurately capturing what's on the analog meter? Or is it in the transmission from the digital unit to DC Water headquarters or whatever it is, or you don't know?
I think of it as the latter, but I would acknowledge that it could be the. I'm not an engineer and myself by training, but what he was essentially saying is that sometimes when there are software or firmware upgrades, there are glitches that happen.
I mean, the reason I'm asking
he
is,
called it a calibration error, a system error, a reporting error.
I mean, the reason I'm asking is I think, again, I don't quote me on this, but I think the testimony was that DC Water then tested the meter, the analog portion of the meter, if that's the right word, against its own digital reading system, and it calibrated. And so it seems to me that it's somewhat necessary for your testimony to have been, your witness's testimony to have been that the error was in the transmission from the digital reader to DC Water.
And I believe he describes it that way.
Okay.
As a transmission error. I think he calls it also a calibration error. It talks about problems with the load profile and how it's transmitted. And obviously, along with our feeling that the ruling about his testimony was in error because there's no certification requirement, it was arbitrary. We also thought it was just prejudicial. The hearing officer made a categorical determination that his testimony was fact and not expert, and then dismissed it as speculation rather than the informed opinion of an expert based on the facts. We think that was prejudicial. As for Mr. Roberts, his story is a little different. He noticed in his July 2020 bill that this was, he believed, 40% higher than his June bill. He testified to that. He delayed complaining because he wasn't sure whether this was something temporary or whether it was something that had to do with what was going on at his home. So he waited. Now, keep in mind that his billing came at a time that customers were less than fully informed of the need to challenge bills within a certain period of time. The obligation on the part of DC Water to put that notice on the front of customer bills didn't come until almost a year later. And DC Water didn't comply with it until August of 2021. I believe it was announced in March of 2021. So the following April, after months of high bills, he called DC Water to say, why was my bill so high? DC Water told him to get a plumber. He did. He had a plumber come out twice. Plumber fixed an issue with his plumbing, his toilet, and then told him, look, this isn't the cause of your high bills. This wouldn't have done it. And suggested he needed to file a challenge, which he did. And then in the ensuing months, he practically begged DC Water to test his meter. They were denying his claims. He couldn't understand why. Again, these are just citizens paying water bills. And he didn't understand why. And ultimately, OPC got involved. When they did, the first thing they said is, where are the meter test results? And then they tested the meter, and lo and behold, it failed. There's no question that the meter led to overcharges. DC Water adjusted the bills for the months they found were timely challenged. The only question is the one the hearing officer asked, which is, when did the overcharges begin? What was the interval? DC Water claimed that that was a hard determination for them to make. They were prejudiced by the delay, but there's no evidence that had they received a more timely indication, they'd have acted more timely. They took 4 months with Mr. Roberts begging them to do it. Mr. Mellum's case, the meter was tested 10 months after the fact. The billing history, we believe, told DC Water what it needed to know. and it's in their initial brief. With the exception of 1 month between November and December 2020, those bills stayed high for the entire period from July 2020 till August 2021 when his meter was replaced.
Can I ask you what your understanding is of, again, technical here, but when the meter is deemed to be outside of the range of acceptable?
What that means?
Well, what does it mean does it mean, what does it mean practically and what does it mean technically? So is the degree of the variation from the standard relevant? That's one. And two, is it once DC water, I mean, maybe this is a question for your colleague on the other side, but if DC water determines that the meter is outside the range of acceptable values, then it's an on or off switch. That means the meter was faulty. And so at that point, DC water concedes that the meter was faulty.
I believe, at least I can handle the second one. I believe what happened here is they found that the meter was not registering accurately, and they went ahead ultimately and adjusted the bills back to a period of time when they believed that the meter was properly functioning. In this case, I believe they went back to 2019 for that interval, before the period of time that Mr. Roberts said, gee, as of June of 2020, the meter was registering too high. As to the first question, I don't know the answer to when it's outside the range, how much outside the range. I assume I believe there's some kind of zone of reasonableness with these meters, but this meter fell outside on the high end. And DC Water has not taken issue that they had to adjust the bills. They did. The only question is which bills did they have to adjust? That was not part of it. Once the meter was replaced, we thought this was significant. The bills dropped. And we point out in our brief, it was roughly around $65 a month lower when the meter was replaced. That's in our initial brief at 37, our reply brief at 14. The hearing officer said that the bills stayed high after the replacement of the meter, but the evidence doesn't support that in our view. That finding is incorrect.
I mean, it seems to me that you would have to concede that I know you take issue with the amount of notice, the level of notice to the consumer about when they have to challenge their bill. But if we assume the 30-day rule applied, that the challenges in April of 2021 were simply too late for everything.
If we assume that it was a prohibition that could not be waived in any instance, no matter what, if it was some sort of jurisdictional limitation that would apply all the time, then the bills are out of time. But in this case, we think as the hearing officer found, that if at any time the meter is found to be faulty, the regulations require that you determine the appropriate interval. And so she made the determination that meant that that the customer should be given a chance to try to show when that interval started. And that was the purpose. That was what was done at the hearing. That was the final decision of the agency, that's what the rules required. We think the evidence properly viewed, especially that billing evidence, demonstrates that interval started when Mr. Roberts said it started. And the fact that the meter wasn't checked till later, or there was no notice earlier, didn't change that fact.
All right, Mr. Strauss, I know we've kept you a little bit over your time. We will still give you a few minutes in rebuttal.
Thank you.
We'll now hear from Mr. Hirsch.
Good morning, Your Honors. Emil Hirsch on behalf of the appellee DC Water. Because this court is obligated in the first instance to determine its appellate jurisdiction, I think it was very proper of your honors to start with the questioning my distinguished opponent about that. DC Water's position is that to both of these consolidated fields, Roberts and Mellon, there is clear lack of appellate jurisdiction. The notion that there was some kind of a pleading error is just not credible. And the reason it's not credible is for the reason that you, Judge Deal, posited. It cannot be reconciled with a statement in the motions practice, the motions to dismiss practice in the summer of 2022, when clearly what they argued is that this was going to be a test case, that they wanted to establish the proposition that under this newly enacted legislation, the DC Water Consumer Protection Act, OPC had its own independent standing to appeal to this court, irrespective of whether the customer appeals. Well, they don't. And the reason they don't is because the statute is not written that way. And even if you look at the legislative history of the subsequent statute, meaning not 34-804, but 2202.5A, and you accept the proposition that the latter statute, 2202.5A, was patterned on the earlier statute. The fact that there is this notable difference in language, where in the earlier statute, which is supposed to be the model, they say represent and appeal from, very expressly, is very significant. And if anything, the legislative history does not support the inference that they're trying to draw. If anything, the difference in the choice of wording, the legislative history supports precisely the opposite inference.
So one thing Mr. Strauss says, and we had a little dialogue about, which you're really the person to ask, what do you mean by footnote 11?
Okay, I was going to get into that. Judge Deals.
I have to say, I found it a surprising footnote, and I'll say I found it surprising because I think I don't think you can have it both ways. I think the natural conclusion from the argument you're making is an all or nothing proposition. OPC can't proceed in its own name. And you say, well, you don't need to say that so strictly. You could just say that OPC can't proceed in its own name absent some cross-cutting interest on behalf of ratepayers. That's quite misaligned with your statutory argument. So let me hear what you mean and why you think it.
I'd like to clarify. And this is your questions are extremely helpful in my thought process. First of all, I want to assure this court, as an longtime officer of this court, that it was not meant to be any concession of any sort. All I was trying to say is that I know from my long-standing experience that courts sometimes prefer to make broad pronouncements, and sometimes they prefer, for reasons of their own, to make narrow pronouncements. All I was trying to say is, if you're not prepared to make a very, very broad pronouncement, perhaps you could make a narrow pronouncement. However, I realize now that my mind has been so totally focused on the issue that maybe that's not possible in a subject matter jurisdiction context, because in subject matter jurisdiction, it's all or nothing. So to the extent that I suggested that there could be some intermediate jurisdictional result, no, that was not the intent, because that would be a concession. And in this case, the more I think about it, the more that's argued, the more that's written, Your Honors, there is a lack of subject matter jurisdiction.
Then let's talk about why that makes sense. And you might say it doesn't, but it's a statute, and maybe that's what we're stuck with. But let's assume some big cross-cutting issue about how DC Water is. Let's just posit there's a systemic problem with them doubling output on their meters. It's a massive fraud, and somebody brings a case, a ratepayer brings a case who they represent, and then they can't contact the ratepayer. And DC Water upholds it and says, no, there's nothing wrong with our meters. They try to contact the ratepayer, they can't get a hold of him. He's gone MIA. Then there's just nothing they can do. That would seem like a pretty big hindrance on their ability to advocate on behalf of ratepayers.
Totally solvable potential hindrance, solvable in several different, specific, and practical ways. While the case is still within that 30-day period where the hearing officer has jurisdiction and it has been appealed, they can petition. They're a sui juris entity. That much, I think, no one disputes that they're sui juris. All I'm saying is they're sui juris without the right to appeal. Okay. But as a sui juris entity, they could file a petition or a motion for intervention before the hearing officer. It is, for instance, in the federal administrative structure, the cases that are decided across the street, especially in the DC circuit, the cases are legend, and there are even 2 Supreme Court cases that uphold the right of a party to seek intervention in an administrative proceeding before an agency post-decision where they honestly come and they say, hearing officer, we would like to intervene so that we could appeal. And often those petitions are granted because either as a matter of right or as a matter of discretion. It's not that difficult. So that's one way they can do it. And that would give them the ability to file the appeal in their own name. So that is a very specific way in which they could proceed. Even if no one of the customers or the parties does anything to appeal. And it is very often the case that interventions like that do occur for that stated purpose, honestly disclosed, and then once they're intervened or they're a party. Now, what happens in this court? Well, you have very specific rule of this court, Rule 15D. Rule 15D says that if you are a party to the proceeding, which they would be at that point, when you are deemed also to be an intervener before this court by the simple expedient of filing a notice. You don't even have to seek leave. But even if you have to seek leave to intervene is rather liberally granted. So that would be the second sentence of Rule 15D. So they had those options. They made a conscious, tactical decision that they wanted to test out this broad and novel proposition that they were given the standing to appeal in their own name, irrespective of what the parties below said or did.
Do you have a view of, so I don't think anybody's talked about Rule 43, our Rule 43, which permits substitution of parties. We didn't talk much with Mr. Strauss about potential substitution. Rule 43 says that upon, if the appellant or the appellee, I think, dies, we allow substitution after notice of the appeal is filed. And then it has a kind of catch-all, and it says that if there's some other reason you need to do it, well, then you just need to follow the procedures described in 43A, which is, I forget exactly what it is, notice to the other party, served on a representative in accordance with Rule 25, pretty mundane stuff. I don't know what to make, and maybe this is unfair because I don't think anybody's talking about Rule 43. I don't know what to make of this substitution for a reason other than death. If that's just like, let's be willy-nilly about it, or if it's meant to capture some other universe of, or what constrains that?
I am at somewhat at a disadvantage for one reason only. Not even Mr. Strauss has raised it in the briefs that he has filed. Not the motions briefs before the briefing started, and not in the various briefs that they filed. I have only seen it in this court in another DC water case that you probably get in a few months, because we're at the beginning of the briefing schedule, where a death did occur and there was a substitution. But to answer your question, Judge Deal, I have never seen it in any context other than death. And I would suspect that the purpose of that rule is limited to successors in interest. You may have a successorship in interest other than by death. Let's suppose I'll give you an example. Years ago, there was there was an agency called the National Capital Reconstruction Corporation. It became a successor agency to an agency that the council abolished. This has to do with the different appeals at the Skyland Shopping Center, which led to the Franco cases before. The original condemning agency was abolished by statute. They were There are cases in the US District Court, there are cases in Superior Court, and I think I argued two before this court myself. So what happened in those cases? I think under the appellate cases, there was a substitution. In the lower court cases, there was a substitution also, because by operation of law, there's a successorship in interest. This is not a successorship in interest, because what he's arguing is that he has a discrete interest that's separate, independent, and does not flow from the customers.
Well,
So I think the
let me
rule
take
would be
you-
misplaced in this context.
Counsel, let me take you in a different direction. Let's
sir.
say that we agree with you. We include something in a decision that, okay, they don't have this interest, they shouldn't have brought it themselves. We've got two customers here who approve the appeal, whose interest seems to be fairly represented in here. Is there some prejudice? Like where is the harm to your party? Was there something that you weren't able to glean from the briefs? Was there something that would prevent DC Water from being able to represent their interest vis-a-vis the two customers? Where's the harm?
Well, Judge Howard, the harm to us is systemic, because I don't know how you would allow these appeals to go forward without ruling in the first instance that there is appellate jurisdiction. Now, once you cross the bridge of the appellate jurisdiction and you go to the merits, they have won. They've won an important point. And the important point is that whenever they feel that they want to appeal, they can appeal with or without the customer.
Well, no, what I'm saying, counsel, is that we say, no, they cannot appeal without the customer. They've messed up in this case.
Right.
But nunc pro tunc, this is really the customers that have appealed, and we're going to hit these merits, but we've explicitly said there's no right for OPC to do this independently in these type of really narrow situations. Is that something you would object to? Is there harm in reaching the merits there?
Anytime if you reach the merits in that situation, I think to be able to achieve that result, one would have to cross a few hurdles, meaning the leave to amend, which they do raise, the issue of whether the leave to amend would be, or the non-protunct would be retroactive to the date when these petitions are filed. And that, Judge Howard, raises some very recent vintage issues for this court. And the reason I say that is because there has been a decision that has come down since the conclusion of the briefing. So that's why I take the liberty to bring it to your attention. It came down on November 22, 2023, Dixon versus United States. It doesn't even have an A3rd number, but it does have a Westlaw number, 2023 WL 8103105, in which a panel of this court, and Judge Thompson wrote the decision, basically moved the ball forward from what it had been in Mathis versus DC Housing Authority, which is a case that is cited in the reply brief of OPC, for the proposition that the Rule 15 is now no longer jurisdictional. It's a claim processing rule, which I could see it is now a claim processing rule because of the Mathis case. But whether it can be equitably told is a different question. And there's a question that this court left open in Mathis. And the question in Mathis is it, do all claim processing rules permit equitable tolling, or are there some that will not? This case moves the ball forward, the Dixon case. And in this case, the panel held that that was a non-jurisdictional, I think it was criminal rule 35 to 100 days for revision of sentence rule. The motion was filed out of time. The issue before the court is, should they allow equitable tolling? The Court of Appeals agreed with Judge McKenna that the motion should be denied, and they affirmed the denial. And they made one very important point. Even as to claim processing rules, you can have a permissive rule or you can have a mandatory rule. But So as to permissive rule, not a difficult decision about whether equitable tolling ought to be allowed if the circumstances warrant it. But as to a mandatory claim process rule, that's the issue that was not decided in Mathis, but it was decided November 22 in Dixon. It was decided adversely to the moving party. And I submit that if your honors ever get to that point, that equitable tolling would not apply in this case because Rule 15 is a mandatory rule. It has no discretionary element. It has no may in it. The Rule 15 is adopted pursuant to the council's authority given to this court under DC Code 2-510, the Administrative Procedure Act. And that language is also mandatory.
I'm glad you mentioned that statute because I was going to ask you that next. It wasn't really briefed, although it was cited 2-510. Maybe I'm misunderstanding something. How does that not arguably independently grant OPC its own standing in this court? It says any person, I'll skip some words, but aggrieved by an order or decision of an agency in a contested case and is entitled to judicial review thereof. And I think we would possibly have to quibble over whether they are aggrieved in their own right. And maybe that's your answer, but.
Well, there's an additional problem in addition to that, Judge Shanker, and the problem has to do with the fact that this court has repeatedly held that although you are an Article 1 court, when it comes to questions of justiciability, like standing and other types of justiciability, you follow Article 3. In other words, you've voluntarily taken on the obligation. And what if you gave 2-510 because of its broad language, its most liberal or a very liberal interpretation, that would stand on its head. And it would eviscerate at least one part of your Article 3 jurisprudence, and that is the standing part.
Well, not if they can separately, and it hasn't really been briefed, but not if they could theoretically separately establish organizational standing under Article 3, which perhaps that's the whole point of their argument here is that they have organizational standing of some sort.
They've tried it, but they've prejudiced me in this case because they've raised that in their reply brief for their merits reply brief for the first time. And frankly, so I've been prejudiced because I didn't have an opportunity to say anything further on it. And there's case law that says that you will not entertain arguments, especially argument that poses as a serious or pretends to be a serious argument, which for the first time is raised in a reply. But beyond that, the argument that they make in their brief makes no sense, Judge Shanker, and here's why. What they're saying is we have suffered an independent, cognizable interest because in the future, but we're going to have to represent others, other litigants like Mr. Mellon, for example, who had this problem with qualification of the expert, as Mr. Cumberbatch. It'll be more difficult for them. But and same thing, if there will be people like Mr. Roberts who in the future are going to face this challenge that their meters are going to be tested 10 and removed 10 months later, and then they'll be at a disadvantage or a handicap in proving, that it was actually the cause. It goes back to an earlier date than the hearing officer was willing to adjust for. Those are not organizational standing injuries. Those are injuries of represented litigants. It's like saying, if I represent a certain type of tort plaintiff before the Superior Court in half a dozen cases, and I lose each one of the cases because of some problem with my expert witness, and the problems have some commonality, then now all of a sudden, someone who.
Well, counsel, that's not a problem with your expert witness. They're claiming a problem in process and how DC Water conducts its investigations, hearings, et cetera. Wouldn't this be the very definition of impact litigation?
I'm sorry, Judge, I didn't catch the last word you said, Your Honor.
Wouldn't this be the very definition of impact litigation? I'm taking this individual case to get a broader change across. I mean, in our past cases, the 2017 case noted at the hearing in Robert's case in front of the hearing officer. I mean, if you go back and read Judge Easterly's opinion in that, no one accused DC Water of being great on procedure or putting everything out. Why don't they have that cognizable interest there?
Because again, I'm at a loss to answer it for organizational standard because it was foisted on me in the reply brief. But what they said in the brief is not sufficient. It is not the formulation that you, Judge Howard, are positing. Perhaps if they put it and cast it in those terms, perhaps there would be some cognizable case for organizational standing. But there is also one thing that has not yet come up in the discussion today, and that I'd like to clarify about the claim of parents' patria standing. You notice that in their briefs, they put basically all of their eggs into the basket of parents' patria. They say that it's because of parents' patria, and they've hedged their bets. They're saying we have parents' patria standing both of the sovereign interest variety and of the quasi-sovereign interest variety. Wrong as to both. If you read the decision of the panel, I think it was Judge Thompson again, the panel that decided ExxonMobil versus DC, a very exhaustive, well-reasoned ruling. The reason why in that case, and the reason why under DC law there exists parent patria standing of a sovereign interest variety is when the party claiming it is an enforcement agency, because the sovereign interest deals with forcing compliance, making sure that what is in the on the books in terms of statutory law and maybe even in terms of case law that applies to DC Water is followed. Well, they are not an enforcement agency.
So you don't think that if they decided to file an equitable action in Superior Court, like the question I posed to Mr. Strauss, saying DC Water doesn't follow any of these procedures, here's our evidence, all of these other cases, and instead of bringing appeals here, brought the people from those cases to testify about it or brought evidence from it, you don't think they could do that because they're not an enforcement agency?
They are not. The Attorney General would have the authority to bring it because their authority to bring that has to be grounded in something. Okay?
Yes, the ability to advocate for ratepayers in 2205.05A, right? Do you think that advocate is just completely vestigial, or what does that add on top of representing?
That statute accomplishes much because it gives them representation and advocacy authority before administrative agencies, federal administrative agencies, the DC courts, as well as federal courts in the District of Columbia, much broader than 804, which is limited to this court and has no application whatsoever to any federal court or the DC circuit. So because it's so broad, it covers 4 items, like I said, but there's only one operative thing. And the operative thing is 2 operative things: represent and advocate. We know what represent is. Advocate in those means that properly interpreted, and what it adds to the represent is that you could have a case where OPC can appear, let's say, before a DC commission or authority that has something to do with water, but is not DC water. It can obviously appear at DC before DC water in a non-adjudicatory capacity. It can meet with a general manager. It can meet with the board of directors if it wants to. It can meet with a DC council. So it can advocate all kinds of policies, legal changes and all that, but not in an adjudicatory context because
I
once.
think Mr. Strauss's response to that was that A3 explicitly uses the represent and advocate in relation to the courts. Represent and advocate for District of Columbia ratepayer proceedings before local and federal courts.
I'm just getting to my point.
Okay.
And thank you for anticipating that it's not complete. The rest of my point is that when you lump federal and state and local courts together in one statutory subsection in 2205 A1, I believe is what you have to be very careful because the DC Council cannot legislate for the federal courts. It cannot change the rules of parens patria, which is a subset of prudential standing. In 804, they could do that because they were limiting their sway, okay, and their scope just to the DC courts. But when they decided to legislate more broadly, they have to be more careful because now, if you take his interpretation to its natural corollary conclusion, he could come in and say with a straight face across the street before a judge of the U.S. District Court that he has standing to institute a U.S. District Court federal question against DC Water, claiming that some procedure that we follow or that we don't follow violates constitutional procedural due process and therefore is null, void, and unenforceable. But the DC Council has no such authority. It's only the federal Congress that has the authority to change the rules of parens patria standing. The council can neither broaden them nor narrow them or do anything to them. And that's the problem because there is this constitutional defect in this in 2205.A1 and because the language is so differently worded than 804 as you cannot construe advocate to mean that it means that they could appeal to any court, state or federal, or that they could just completely bypass the notion that even when they file a suit in superior court under the hypothetical that was posited earlier, even that requires case or controversy. The DC Council cannot abrogate the constitutional standing rules that apply. And one of the things that exists here, there's not only a defect on the prudential standing side because there's no injury, in fact, cognizable that they have independently for either constitutionally or for parens patria purposes, because part of the parens patria is that you also have to have a case or controversy and a concrete injury in fact, and that just doesn't exist. I'd like to say,
can we get, you're well over your time, but we can give you a couple more minutes if you'd like to say something about the merits. But I think we've covered the predicate question enough, unless my colleagues have additional questions.
I would like to also say before I go to the merits that there is no quasi sovereign interest in here that's cognizable, because it's very clear from the Exxon decision that what this court requires is the wording is substantially or sufficiently substantial number. In other words, it has to be a dispute of some numerosity. They don't have that. They have individualized disputes, even as to the the two customers that are involved. The disputes that they have, each one is very particularized. There's no commonality. There would have to be a record established before the case gets to this court. So a record would have had to have been established before the hearing officer to show that the dispute, these problems affect a sufficiently substantial number of the DC rate-paying citizenry. Now, thank you, Judge Deal. As to the merits, I have 3 points to make. With regard to Mellon, the rules of Gatewood were properly applied. We concede that a Gatewood type of prima facie case was made by the customer. He was rebutted by DC Water. How was it rebutted by DC Water? Well, the meter testing in that case proved that the meter was functioning properly. The testing of what is called the MTU, or the transmission device, showed the same thing. In other words, when they tested the reading at the location versus comparing it to the remote reading where the device transmits to, those two readings were the same. Under Gatewood, that now shifted the burden to the next burden of production, and the burden of persuasion always remains with the customer. And the quality of the evidence was not sufficient, and it was of very poor quality.
Sorry, go ahead. You're kind of asking somebody to prove a negative. I mean, what more can you do other than, I didn't use 30,000 gallons of water those few days. Even if the meter works, the fact testimony is I didn't use that water. And doesn't DC Water need to rebut that? Need to come up with some plausible explanation?
Well, the plausible explanation, the most important explanation and the most objective explanation was not the self-serving testimony that one could offer, through your witnesses, but through these meter results. That put the burden back on the customer. The customer.
That's what my question is, counsel. It was my understanding, and please correct me if I'm wrong, and maybe I am, that there was a test of the central kind of digitized unit. There was a test of this MTU unit, but I thought there was an open question, like there was not a test of the on-premises actual meter itself.
Well, the meter was not defective. And because the meter was not the meter function, that particular meter functioned normally, which would not have, which then rebutted the prima facie showing. So now the burden of production on the Gatewood shifts back to the customer, who always has the burden of persuasion. And that's where the problem is.
Would the meter not, if there was a calibration error, would the meter not show up as functioning perfectly normally, though it would be reading wrong?
I don't know whether technically that would be the case, but what happened here, and also, and my last point about this, the Mellon case, before I segue into Roberts, is that the error is harmless, and it was the error regarding Mr. Cumberbatch, because he was allowed to testify. He was allowed to testify fully, and there's not a scintilla, not an iota of reference in Ms. Blassingame's decision to suggest that she did not credit him. An unrebutted, whatever he said.
Well,
As
if he's,
fact
I mean,
witness,
if he's a
you cannot
fact,
disregard.
if he's a fact witness, that's what entitles her to call it speculation. If he's an expert witness, that would counsel in favor of her saying, based on your experience and expertise, I credit your testimony that this type of glitch that you're talking about happens, right? That's the
But
difference.
Judge Schenker, with all due respect, with regard to fact witnesses, she has lesser leeway than with an admitted expert witness, because even as to an admitted expert witness, she had the discretion to give it any weight, no weight, some little weight. In other words, that the extent of the weight that she would have had to give him is entirely up to her. But here there is no indication on the face of her decision that she did not, that she disregarded this testimony or that she gave it no weight. And she also correctly observed that there were things that he was basically raising hypothetical scenarios. The fact that it could be a glitch caught in the upgrading of the system. When asked whether he's aware whether the system had been upgraded, he very candidly admitted on cross-examination that he wasn't aware. He did not know whether the system, so it was a
Of
pure.
course he didn't, but could DC have said that? Could DC Water have said that? I mean, he wasn't a DC Water expert. He wasn't a DC Water employee. He couldn't see any of that. So why does that matter? You know, it's hypothetical, but the people with the evidence were your party. And and what we're hearing from the other side is that evidence about software updates and other things didn't come in, that there were basically just big gaps when it came to the rebuttal evidence from DC Water. How did DC Water fill in those gaps?
Well, I think that the point, nevertheless, is well taken, that when they tried to rebut through Mr. Cumberbatch, it was the type of rebuttal that was inadequate to carry the burden of persuasion. And all Ms. Blassingame did at that point is to say that they hadn't carried their burden, which is a question of fact.
Can I go back to something you said earlier, which was that the best objective evidence against Mr. Melham was that the meter was determined to not be faulty. So you seem to be arguing then that the burden shifting analysis essentially ends at stage 2 in all cases when your client has determined that the meter is not faulty. I guess my question is, what evidence could the consumer ever come forward with at stage 3 of the burden shifting analysis that would overcome DC Water's determination that the meter was not faulty? Can you come up with an example, especially in a case where we're talking about 34,000 gallons of water?
Okay. One possibility that I can readily think of, Judge Schenker, is a situation where the meter is not faulty, but there is a disparity in the reading at the site versus the reading at the location to which the MTU unit transmits, which at that point raises an inference that there could be something wrong with the MTU. That's one, that's the most obvious possibility. I suppose in a case like this, where they could have rebutted it, and perhaps successfully, if they had adduced some evidence where they were not just positing hypotheticals and hypotheticals that were not provable because the underlying foundation for the hypothetical didn't exist. So for instance, a case where there was a systems upgrade coupled with testimony from an expert that the relative frequency of errors occurring in the transmittal because of glitches once you do the upgrade, then that would not have been speculative, because then Mr. Cumberbatch or whoever would have been the alternative to Mr. Cumberbatch would have been relying on not just on a hypothetical, would have been relying on something that had grounding, it had a foundation.
But in this case and in that case, like all that foundation is all with DC Water, right? And as I looked through the transcript, DC Water said they didn't know whether there were any updates. And so how could they possibly prove those kind of things when the information is all with the utility and not ever potentially with them?
Okay, well, we occasionally, Judge Howard, we encounter very, very aggressive litigants. And sometimes they're represented by counsel, and sometimes they may not even be represented by counsel, who have sought discovery rights from them. Discovery is discretionary. It's not unheard of. It's definitely not unheard of. And those are the kinds of things that preparation and asking for leave to discover probably would have given someone a closer edge in carrying that trumping burden, that step 3 in the burden of persuasion. Now, if I may, in my final moments, if I may just say something about the Roberts case. In the Roberts case, the only dispute was really how far back you go once you ascertain that your meter is defective. And they were given an adjustment. It was an adjustment for a limited period of time, the time that both stated the written challenge or dispute to the bill, and not to the part before. The regulation was not misconstrued because the regulation says that the adjustment is for the interval that the meter is defective. Here, there was testimony. It rightfully became a factual question. There was nothing arbitrary in the way the law was decided.
It's a little arbitrary. Is it a little arbitrary to say, oh, if you're going to complain about my water bill is high, 1 month that's a little high, it makes sense that you might say, oh, it's 1 month. 2 months, oh, that's a pattern. 3, oh, well, now I'm going to complain, but you're saying you don't get recompense when it turns out your meter was faulty. You don't get recompense for the first 3 months because you hadn't complained early enough. That seems arbitrary to me.
Yes, but in this, but there's a reason why this particular result was adopted by this hearing officer. She didn't just pull the untimeliness out of thin air. What she said is, I am confronted with a regulation that says that I have to adjust it back to the duration. So now I'm going to limit my inquiry, which is totally proper, to ascertaining the duration. Now, when there is contributory fault by the customer to the inability to determine the exact duration back in time, it is not arbitrary and it's not capricious to decide it based and to use as a default rule the timeliness or the actually in this case the untimeliness of the challenge. And here we have 4 strikes against the Roberts. One is they were home a lot during COVID. A new sprinkler was installed. A toilet flap was fixed. And then there was, even after the meter was replaced with a new functioning meter whose good function was subsequently confirmed, I think in December of 2021, there were spikes even in the period that postdates the replacement of the meter. So you have 4 circumstances like that. If there was nothing else, okay, before the hearing officer, other than the untimeliness, the ruling may have been very different, but it's clear that her ruling is a uniquely factual ruling. She found that they did not carry their burden as customers by a preponderance of the evidence to that there was meter malfunction at an earlier time, going all the way back to June of 2020, when they first noticed that there was something wrong and the bills were and the consumption.
So assuming we agree with you there, which I think it's a reasonable point. What makes the magic difference for there's at least that 1 month period with the April 14 email? Why is that not enough notice for that one additional bill?
Okay, that there is, it is our position that whatever error is involved in that particular situation with that one bill is harmless, because she gave them the opportunity to fully litigate that also. In other words, it was all laid out before the hearing officer, which brings me to the last point about Roberts. In Roberts, I want to remind the court that we have a cross appeal also. And our cross appeal is very simple. It says that if you were inclined to reverse in the Roberts case on the merits, there is one final trumping consideration, and that is the error in denying the motions to dismiss and the motion for reconsideration in the Roberts case. Because those were founded, at least the motion to dismiss clearly was founded on the fact that the hearing officer misread Gatewood, interpreted Gatewood in an overexpansive and unjustified way.
Can I ask you a question about your ability to cross appeal in the first place?
Yes.
Because it seems to me that the decision below was a decision of the agency. I know DC Water is an authority, but I think it's treated as an agency. I'm anticipating your response, which is that a hearing officer is a neutral third party. But the regulations contemplate that the administrative hearing can be run by either the general manager or a hearing officer. And if that's the case, those two terms seem to be analogous in the reg. And if the hearing could be run by a general manager, then that certainly seems to suggest that the administrative hearing decision is a decision of DC Water, which means you couldn't appeal your own decision, right?
Judge Schenker, I've thought long and hard about this. And I think we cited a case by the name of Lee versus, I think it's the CAB, where there's a dissent by Judge Prettyman. I think Judge Prettyman's dissent in the early 50s has in effect become the law. So it's when you interpose an independent adjudicator between the agency and the customer, and that independent adjudicator is subject to rules or regulations, is mandated to follow the law, is not given totally wide range, and is not subject to being overturned by an agency official. And the independent is not even part of the agency. She happens to be a private sector.
Well, that happened here, but what if DC Water had exercised its option to have the hearing run by the general manager? I don't know who this general manager is, but that's what the regulations say. Is that still your position?
I don't know honestly what my position is, because I haven't thought that through with a degree of care that I would like to think these things through before I make representations. But it may be a different result. But on the other hand, it may not be. I honestly do not know the answer to that. But here they interpose this independent review, and that's the difference that it makes. Because if that does not create the separateness that is between agency and adjudicator, then nothing will, because then every single case that comes before them from DC Water would be challengeable by the customers or by OPC by saying, well, you didn't give us due process, because we're entitled to a fair, impartial, neutral person from outside your agency. Your agency cannot be prosecutor and party and adjudicator. So in other words, you could not have a sustainable, workable system that gives folks due process.
We understand your argument, Mr. Hirsch. Thank you so much. We will give Mr. Strauss a few minutes in rebuttal.
Thank you.
Try to cover as much as I can in the time we have. Judge Howard, to start off, you had posited that in the Mellon case, the DC Water did not test the meter. They did test the meter, but they didn't test the meter transmitting unit. That's in the transcript at page 960 to 961. They clearly admit that they did not. And in that sense, this case, the Mellon case, is the flip side of the Gatewood case. In that case, they tested the meter transmitting unit, but not the meter. And the court found that that was insufficient to rebut the prima facie case that had been shown. Questions about our standing. We believe there's several bases again for standing, the statute, but beyond that, the parents patriarch point, which we raised in our brief, in which OPC has been put in the shoes of the sovereign under the statute. We are to represent and advocate for water customers. That gives us the authority to enforce the statutes against DC Water on behalf of customers. We believe that makes us different and therefore entitled to an opportunity to participate. Also, parents patriarch standing gets beyond prudential standing concerns. You don't have, the law is that if you have parents patriarch standing, you've met prudential concerns. If that's not acceptable, then as I pointed out, I believe the caption fairly read and the petition fairly read includes both OPC and the customers. And if OPC cannot appeal, certainly the customer should be able to appeal. Finally, in our response to the motion to amend, the motion to dismiss, we asked alternatively for the opportunity to amend the petition if necessary, so that the customers, if they are in fact the real parties in interest, have an opportunity to have their claims heard in this court. The purpose of the court's rules should not be to prohibit customers from bringing their issues to the court. I think the public interest would favor hearing those claims, even if OPC could not be the one to bring them. I'm unfamiliar with the case, the recent Dixon case that counsel cited during his argument, but I do know that the Mathis case says that Rule 15 is a claim processing rule, and certainly the equities here would support standing. The customers clearly intended to appeal. The decisions are before this court. The various information that's in the petitions makes clear that the customer is before the court. And I thought the question that the court asked is, what was the harm to DC Water? I didn't think had a satisfactory answer. I still don't know what the harm was. They clearly understood the issues that.
But I mean, would you agree that if we agree that it's a mandatory claim processing rule, and that it's subject to some sort of equitable discretion, that equitable decision turns to some extent on whether your decision to do what you did was intentional or not. And it seems you've acknowledged that it was at least partially intentional.
I think it was partially intentional appeal in our own name and on behalf of the customers. I think it was both. I think that's what we were trying to do. And I think more importantly than that, we clearly were trying to bring the customers' claims before this court, and it would be very inequitable to conclude that this court did not have an ability to hear those claims, for sure. On the issue of the cross appeal, I don't see how they have an opportunity to sue themselves. Counsel posited a separation between the hearing officer and the general manager.
Why isn't my reaction to that argument in this appeal has been, well, who cares? Let's assume they couldn't cross petition. Why couldn't they just raise this as an alternative basis to affirm DC Water's judgment? Because
their obligation as counsel for DC Water is to defend the decision of the agency. They don't get to rewrite it on appeal.
Well, not to defend the reasoning. They can't posit alternative bases for the same outcome.
I don't think they could.
They need to say we're defending the reasoning of the adjudicator all the way down.
I don't see how they can posit an alternative reason that was specifically rejected by the final decision of the agency. Their agency counsel, they would have an obligation under the law to defend the decision. They don't get to rewrite it. And effectively by cross appealing, essentially the caption becomes DC Water against DC Water. They're appealing.
No, it's still OPC or Roberts and Mellum versus DC Water, depending on how you want to count it. And they're just saying that we got it right below for different reasons than what were articulated by this independent adjudicator. That seems pretty normal.
I don't see how they could defend the decision on the basis of a ruling that the hearing officer specifically considered and rejected.
Right.
I think that their obligation as agency counsel is to defend the order as written. For example, the staff of the Public Service Commission issued an order. They can't come into court and say, well.
That would make a lot of sense if they were in the position to amend the order, to change it, if it were.
Say it again.
I said that would make some sense.
If
it were really their decision and they could amend it and they could change it, then they should come up and be stuck with it. But I mean, there's a lot of sense to if you have a third party adjudicator interposed. It doesn't make any sense to me that you would be stuck defending their reasoning.
Sure. Thank you for the question. Remember that under the regulations, under 21 DCMR 414, the general manager delegates to the hearing officer to issue final decisions on behalf of the agency. And keep in mind also that DCMR 408.1, which deals with inconclusive findings, which is one of the points that was raised in this case, certainly by the hearing officer, states specifically that in cases of inconclusive findings, there won't be an adjustment, except as may be approved at the sole discretion of the general manager, based upon a determination by the owner or occupant that an adjustment was necessary in the public interest. If the general manager felt that the decision was incorrect, that there was some overriding public interest that required him to override the hearing officer's determination, I think he had the authority to do that. He didn't do it. It came in as the final decision of the agency, and I don't think agency counsel gets to come in and try to say, well, actually, it should have been something else. If you reverse on one grounds, you should take it back again and rewrite the agency decision on appeal. I don't see how that can happen.
All right, well, unless my colleagues have any final questions, thank you, Mr. Strauss.
Thank
We
you.
appreciate it. Thank you, parties, for the briefs and the interesting arguments. The case will be submitted and the court stands adjourned.
All right.